Hello everyone, I think we can start now, and the one who wanted to attend has done it. And the others are not that lucky. So, my name is Oleg Zaytsev, and I am a chairman of the Bankrotный Club. It is an informal organization that is created to unite people who are interested in insolvency law. This club was created by the Alexeyev Private Law Research Center and is supported by the Statut Law School. And today we have a very special meeting. We have a privilege today to listen to Matter Sары Allúche. Sorry for my French, it's awful. I studied it only for one day. And when I was told that there are 6 ways to pronounce the sound A, I thought, it's very difficult. Very difficult for me, unfortunately. That's why Matter Allouche agreed to talk in English to us. Thank you very much for that. She is a French attorney, correct? She's attended to the French bar, and she will give us a lecture on the reconstitution of the asset of the debtor facing an insolvency procedure today. We are recording the meeting, and Matter Allouche agreed to publish the record on the website, so those who would like to listen to it will have an opportunity. Please, those who would like to ask questions and make comments, switch on your microphones so that we could record it. What would be more appropriate for you, to ask questions during the lecture or after it?
During the lecture, if it suits the people.
Okay, so please feel free to do it. But we will, of course, have some time after the presentation for questions, comments, and so on. And I would also like to tell you that French insolvency law is unfortunately terra incognita for Russian lawyers. We are very much influenced by German law. We have even some translated books from German into Russian, but unfortunately, we know almost nothing about French insolvency law. Though our legislation that existed before the social revolution was very much influenced by French law. For example, the Actio Pauliana existed in our civil code before the social revolution, and it was taken from the French civil code. Now we absolutely forgot it, and now we have no provisions for out of bankruptcy Actio Pauliana in our civil code, but we do remember that we had it, and that French civil code helped us to understand this construction. So now I'm finishing, and very glad to present Matter Sары Allúche to you. Please, Bill.
Thank you. So thank you for inviting me for this lecture. I will talk to you about the reconstitution of the asset of the debtor facing an insolvency procedure. But first, I will make you a brief presentation of the French bankruptcy laws. I will talk to you about the reconstitution of the asset of the debtor through the période suspecte and the action polienne. And in the third part, I will talk to you about the community insolvency proceedings. So let's start with the presentation of the French bankruptcy law. The French bankruptcy law is organized according to the level of the financial difficulties with which the company is confronted. There are therefore 2 phases from the treatment of the difficulty, a preventive phases with 2 tools, the ad hoc mandate and the conciliation. The processing phases has 3 proceedings, the safeguard procedure, the receivership, and the compulsory liquidation. The ad hoc mandate is the simplest tools. It's an amicable procedure in which the manager of the company asks to the president of the commercial court to appoint a receiver. This procedure aims to facilitate negotiation with the principal creditors of the company to obtain delays of debt write-off and to review the contract that could affect the outcome of the company. Its major objective is to search for new financial partners, because the result of this company is to ensure long-term solvency for the company. To open an ad hoc mandate, the company must not to be in situation of cessation of payment. This ad hoc mandate could end by the signature of one or several protocols, or by the opening of the conciliation procedure. The conciliation is a short procedure, maximum 5 months, and a confidential one that allows to solve difficulties under the protection of the court. This procedure aims also, and as the ad hoc mandate, to facilitate negotiation with the creditors of the company and search for new financial partners. And for this proceeding, the company can already be in situation of cessation of payment, but less for 45 days. Like for the ad hoc mandate, this proceeding could end by protocol, but they have to be approved by the commercial court, or if the negotiations are failed, there are the opening of a safeguard or a receivership proceeding. The French bankruptcy law for the processes phase contains 3 types of procedure for the treatment of difficulties: the safeguard procedure, the receivership, and the compulsory liquidation. They may be opened when the company is in situation of cessation of payment. The 3 proceedings have all for objective to handle the financial difficulties of the company, either by the adoption of a recovery plan or by a disposal plan in which the company is sold. Can be eligible to a collective proceeding all commercial companies, associations, sole traders, and liberal profession like lawyers. The people must not already have to be the subject of a collective proceeding. And for all the 3 proceedings, the company must be in a cessation of payment. Only for the safeguard, the company must be in situation of cessation of payment for less than 45 days. Can ask for the opening of these 3 procedures the company or its manager himself by the declaration of the cessation of payment before the commercial court. Only for the receivership and the compulsory liquidation, the company may be sued by an unpaid creditor. The company could always be sued by the public prosecutor, and for the 3 procedures, the court could seize it automatically. When the procedures are open, there are some consequences for the company itself and its manager. In the safeguard and the receivership, a receiver is appointed. He has 3 types of mission: assistance the manager, surveillance of the manager, and the divestor of the manager. The receiver manages the company and has to establish an economic and financial situation of the company to consider either a safeguard plan or a recovery plan or a disposal plan. A judicial representative is also appointed. He has quality to act in the name and in the interest of the creditor or the company. The creditors thus have to declare the claim in the hand of the judicial representative, so that can be, when necessary, integrate into a continuation plan to get a dividend. In the compulsory liquidation, only a liquidator is appointed. He combines the role of the receiver and the judicial representative. As the receiver, he represents the company and replaces the manager. And as the judicial representative, he acts in the name and the collective interest of the creditors, and the claims are declared into his hands. But sometimes in compulsory liquidation, the liquidator could consider that the manager has committed management mistakes which are the origin of the insufficiency of assets. If so, the liquidator can sue the manager and obtain sanction against him. This sanction could be the condemnation of the manager to fill the insufficiency of assets. In this case, the manager will have to pay the maintenance of the insufficiency of assets. It can be condemned to personal bankruptcy and a prohibition to manage for about a maximum 15 years. Let's see briefly the three proceedings. The safeguard proceeding, it's a procedure in which the company will benefit the protection of the courts. All the proceedings against the company are suspended, and the receiver has to establish a safeguard plan with the manager. This procedure aims to encourage the restructuring of the company in order to ask the return to a financial stability and ensure a long-term solvency for the company. But if the safeguard procedure fails, it will be converted into a receivership. The receivership procedure has the same characteristic as the safeguard procedure, because the proceeding of the creditors and pledge are suspended. The receiver has to prepare the recovery plan with the manager, and there is an absolute prohibition to settle previous claim since the opening judgment. It also aims to encourage the restructuring of the company and to ensure a long-term solvency. But if the receivership fails, the company could be now faced to a compulsory liquidation. Its characteristics are also the same as the receivership. According to the creditor, all the proceeding and pledge are suspended. There is the same prohibition to settle previous claim. The liquidator has to prepare the disposal plan with the manager, and in order to sell the company, either by a disposal plan or only with the disposal of assets, because the objective of the compulsory liquidation is to ensure the continuation of the company if it's possible. But in the most cases, the company is sold to preserve the employment by the sale of the company and to disinterest the creditor. The final result is the adoption of the disposal plan. So let's talk specifically about the reconstitution of the assets of the debtor. It often happens that the organ of the collective proceeding have to realize several initiates to reintegrate in the company the assets that went out of it. The economic parameter to consider is the date of the cessation of payment of the company. This is the date from which it is considered that the company can no longer face its current liability with its available assets. This date is fixed by the court when it's open the collective proceeding. This date, it corresponds either at the date on which the manager filed for bankruptcy of the company or on the date on which creditors have registered privilege or security against the company. When a court fixes the date, it may fix it within a maximum of 18 months before the commencement of the collective proceeding. The date fixed for the cessation of payments open a period called, in French, la période suspecte, and the period of suspicion. It's the entire period up to the opening judgment, and it will be analyzed to verify the regularity of some transaction carried out by the company or its manager, and it's necessary to allow the asset to be reinstated through the cancellation of operation relating to these acts. But as a general rule, a company is not brutally confronted with the opening of a receivership or a compulsory liquidation. The bankruptcy is often preceded by a period of time, more or less long, during which the company or its manager can be tempted to realize certain operations to try to clean up the situation. But often the operations have the effect to impoverish the company or to exacerbate the difficulties, to favor certain creditor to the detriment of the other, and to organize the insolvency by realizing liberalities or gratuitous acts. For a long time, these operations were declared enforceable. They could not produce effect in the collective proceeding. But since the law of July 25, 1985, and all subsequent reforms, the transactions concluded by the company are non-null. Have the right to cancel the transaction prejudicial to the debtors or his creditor, and thus to reconstitute the asset of the debtor, the receiver, the judicial representative, the commissioner for the plan implementation, in French, commissaire à l'exécution du plan, and the prosecution. They thus have the possibility of requesting the annulment of all acts concluded during the period of suspicion. There are two types of nullity, the nullity of right and the facultative nullity. There are 11 operations which could be considered null and void if they were made during the period of suspicion. The first, all gratuitous transfer of personal or real estate property. It could be donation, even if the beneficiary is in good faith, and donation between spouses. It could be the constitution of the security interest, like a mortgage, a personal bond, or a waiver of succession. The two, any commutative contract in which the obligation of the debtor significantly exceed the one of the other party. The imbalance is appreciated at the date of the conclusion of the contract, but only towards the term of this contract and not in relation to the clause in other contracts signed between the same parts, and by considering the operation itself and not the operation generally concluded for the same business. 3. Any payment, whatever the mode, for debts not due on the day of the payment, like novation or payment by transfer or professional receivable. 4. Any payment for due debts other than in cash, bill of exchange, transfer deed, or other method of payment commonly accepted in business relation. The method of payment is appreciated toward to the specific circumstances of the professional sector, and no matter if it was originally plain between the party. Were considered like invalid payment the transfer of a claim from the benefit of the USAF for the payment of contribution, because the USAF, in French, it's an institution who collect all employment charges. They are not considered like business relationship. Another invalid payment is the return by a buyer to his supplier of goods bought in return of the emission of a credit note and the partial discount of stock, but was declared valid the legal compensation and the conventional compensation, since the method of payment is collectively admitted in business relationship. But the nullity does not extend to the convention validly concluded under which the payment was made. 5. Any deposit and consignment of sum ordered in a judicial proceeding in the absence of a final final court decision in force of res judicata. This one must be acquired at the date of the opening judgment. 6. Any legal hypothec and legal hypothec between spouses, any legal pledge or guarantee of the debtor property for debts contracted previously. In this case, the security is void if it secures a debt previously voluntarily contracted and not a debt resulting from judicial decision constituting claims, such as the return of the benefit provided under a counsel contract. Nullity concerns also judicial pledging. The nullity is imperative as soon as the safety created after the cessation of payments, such in case when the Constitution intervenes on the very day of the opening judgment, on when it intervenes after the cessation of payment, although under a previous promise. But the nullity is set aside if the safety was created before the cessation of payment, even it was registered afterward or still when its creation is concomitant of the birth of the guaranteed claim. The pledge of an intangible asset is constituted as soon as the contract recognizes it is signed, because its publication has the sole effect to make it effective against third parties. 7. Any protective measure unless the registration of the act of seizure is prior of the date of cessation of payment. In this case, the nullity applies to the registrations made by the debtor and to those made by the creditors. The nullity does not apply to an enforcement measure, like a third-party notification, but they can be cancelable too. It does not apply either to the definitive registration taken after the opening judgment, since the temporary registration was taken before the cessation of payment. If the registration is cancelled, the conversion of the seizure is also void by consequence. 8. Any authorization and exercise of option granting employees to the right to subscribe for shares of the employer company. 9. Any transfer of the property or the right in the patrimony in a trustee, unless the transfer intervenes at the guarantee of a debt concomitantly contracted. 10. Any endorsement to a trust agreement affecting rights or property already transferred to a trustee patrimony to the guarantee of debt contracted before the endorsement. 11. The declaration of non-seizability by the debtor for one of his real property. For this 11 operation, no matter what they could damage to other creditor, the other part has no knowledge of the date of the cessation of payment, and the act was performed by the debtor or by a third. I'll talk to you now about the facultative nullities. At the request of the organ of the procedure, the court can cancel 3 types of acts. The gratuitous transaction on movable or real estate assets of the debtors, like donation, when these gratuitous transactions are realized during the 6 months preceding the suspicious period. This also included the declaration of non-seizability made by the debtor 6 months before the opening of the collective proceeding. These acts are, in fact, suspicious a priori and constitute an impoverishment of the debtor, which may be disputed in the interest of the creditor and of the rescue of the company. They generally realize for the benefit of the relative of debtors, with whom he has ties of kinship or friendship. The second category is the payment on contract for valuable made during the suspicious period, when those who have dealt with the debtor have knowledge of the cessation of payments. Are cancelable a contribution to a company, an acknowledgement of debt, and a remittance of good in storage against an advance, but were not cancelled an assignment of daily receivable related to a transfer agreement entered into prior date of cessation of payments. The last facultative nullity concerns any third-party notification, seizure of assignments, or any objection may be set aside when it has been issued or practiced by a creditor from the date of cessation of payment of which he is aware. As for any facultative nullity, the court can refuse to pronounce the nullity even though the conditions are gathered. In every case, it's up to the applicant in the nullity to prove that the third party knew the cessation of payment of the debitor. It may be proved by any means and result, for example, from family relationship or continuing business relationship existing between the debtor and the third, or by the granting by the creditor of abnormal payment term. The nullity has the effect of reconstituting the asset of the debtor and of reinstate in his patrimony the corresponding asset or fund. The asset in question is reinstated in its entirety, even if is it an asset of spouse and on which the spouse had the control. The debtor who had reinstated good can be condemned for theft, since the good was, after all, during the compulsory liquidation sold by the liquidator to a third, because it has subtracted it from the assets of the liquidation. Thus, any compensation is excluded between the debt of restitution consecutive to the pronouncement of the nullity owed by the creditor and the claim this creditor is admitted in the liability would it have arising during it would have been borne during the period of observation. The creditor whose security is declared null is reduced to an unsecured creditor rank, and the person whose payment has been cancelled recover his claim and has to declare it. But when the nullity was pronounced, any interested third part can invoke it. He may do even against a sub-buyer, even if it's good faith, who cannot evoke to defend himself either the common error or the appearance. Now let's talk about the action polienne. How did you say? Actionnel?
I think it is understandable.
Okay. Okay. The action polienne is governed by the French Civil Code, and it also allows the creditor to obtain the revocation of the fraudulent act made by the debtor. The common object of the action polienne and the action in the nullity is the annulment of the suspect or fraudulent act made by the debtor. There are 6 distinctions of the two actions. The first distinction, in the action polienne, the plaintiff in the action has to prove the fraud of the debtor, while is it presumed for a case of nullity of suspect period. The second distinction, the plaintiff in the action polienne has to establish the complicity of the third if the act is a contract for valuable, while for nullities of suspect period, the complicity is either presumed or easy to establish because the good faith of the third is indifferent. The third distinction, in the action polienne, it's required that the act cause a prejudice to a creditor by causing or by aggravating his insolvency. The fourth distinction, the sanction of the fraud polienne is the non-imposability of the fraudulent act to the pursuing creditor, while an act passed in suspect period is cancelled toward all the creditors. Fifth distinction, the action in nullity of suspect period is only for entitled person, the organ of the procedure, and allows to attack the validity of acts which escape the action polienne, such as payments or shares. Sixth difference, the purpose. The action polienne is intended to sanction a fraud committed by the debtor. The action in nullity of the suspect period can also have such a result, but its purpose is much wider in reality because it's intended to reconstitute the asset of the debtor and, consequently, penalize acts of impoverishment or acts that are prejudicial to the company independently of their fraudulent character, such as payment of not fallen debt, constitution of security to guarantee previous debts. It's all about to call into question acts that compromise the recovery of this company and of reconstituting the forces of the enterprise in the interest of the economic unit itself. I will ask you 2 questions. The first, can the organ of the procedure can commit the action polienne? And if so, how this action can articulate with the one that could be hired by a creditor? The answer of the first question was established by a judgment of the Cour of Cassation in 2001. The judicial representative and the commissioner in the execution of the plan may commit the action polienne in the name and in the interest of the creditor. So the action polienne, as formally, can therefore be a collective action implemented by the representative. Thus, the action is admissible and the inopposability of the act will be pronounced in the interest of all the creditor, even if the sanction is contrary to the interest of one of the creditor. The action benefits all creditors since it's committed in their common interests. The second question, how articulate the action polienne committed by a creditor and the one can be committed by a representative? There are two hypotheses. The first one, a creditor and an organ of the procedure want to commit the action polienne because the action in nullity is not admissible, because the suspect act was committed before the date of the cessation of payment or before the period of suspicion, because the condition of application of the nullity of right or facultative nullity are not gathered, or naturally because the court didn't fix a suspect period. In this case, the creditor and the representative have the right to commit the action polienne, but the result of their action would be different. If the creditor succeeds in his action, the fraudulent act is not invocable and deprived of effect only towards him. If the representative acts, the act will be deprived of effect toward all the community of the creditors. If the representative joins the action polienne committed by the creditor, the result of the action will thus be collective. The second hypothesis, a creditor wants to commit the action polienne while the act may fall under the nullity of suspicious period. In this case, his action will be rejected because it undermines the monopoly of the organ of procedure to dispute the suspect act. Do you have any question before the part 3?
Part 3 will be
the community insolvency proceeding.
I have some, but I think that maybe the others have that one. I do not have a monopoly or collective organ, so any questions maybe? No? No one? Then maybe could I? Well, my first question will be, let's imagine that a creditor filed an action on action polienne, right? Because we call it action polienne, and he lost the case. For example, and the court decided that he couldn't prove the
fraud.
Yeah, the fraud or something like that. The other party acted in bad faith, something like that.
Sorry.
Sorry, I didn't. So should I repeat it? But study it? Okay. So, and then the collective procedure is opened, and the other creditors get the knowledge of this act. For example, their collective representative finds this transaction, and they want to annul it to the bankruptcy laws. Are they anyhow affected by the previous court's decision, or they are absolutely free and will do it not anyhow connected with it, and the court in the collective proceeding will not be anyhow bound by the decision that was made in the Action Polienne case?
The creditor who commit the action polienne has to prove as a first condition that the act caused damage to himself. Okay? If the other conditions are not gathered, the fraud, the complicity of the third part, the the court can not pronounce the nullity of this operation, and it will be difficult for another creditor to commit the action polienne about the same operation. And for the representative, they can also only commit an action if this operation, which will be not declared as an action polienne, is damage to the collectivity of the creditor. If this operation is not has not the effect to create a damage to the community of the creditor of the debtor, they can commit the action polienne. The representative can only commit the action polienne if the act makes a damage, and principally if the act cannot be disputed with the nullity of suspect period.
Okay. And my other question will be about the limitation period.
Hmm?
When does it start for the collective representative?
For the judicial liquidator and for the receiver? There are several options. The classic one is when the collective proceeding is open, the date of cessation of payment would be fixed at the date of the opening judgment. It can be fixed also 18 months prior the judgment of opening, and the representative will have the receiver, the liquidator, and the judicial representative will each by each analyze all the operation made by the debtor during this period. But it could be 3 weeks, 6 months, 18 months. It's the period fixed, the limitation of the period is fixed by the court. But in all this period, they could check all the operation, and they could ask for nullity of any operation who make a damage to the creditors of the debtor, and which had come as consequences to create the insolvency and difficulty, because the act make an impoverishment for the creditors.
My other question will be, may the defendants, the third parties, anyhow dispute the date of the cessation of payments, because they didn't take part in the proceeding when it was discussed, so they can do nothing?
Now, in French bankruptcy law, the only part who can dispute the date of cessation of payments is the debtor himself.
Isn't that strange?
Yeah, it's very strange, because he has to convince the Court of Appeal that it was in good faith for the period fixed by the Court of Opening Judgment, that he had made no operation to impoverish himself, and he had not made create the insolvency voluntarily of its company. In 19%, all the proceeding made by the debtor contesting the date of the period cessation of payment are rejected.
And, my final question, though I'm almost sure what the answer will be, but I would like to ask it anyway. If, for example, the defendant, the third party, finds that most creditors of the debtor are false, and the debtor filed for insolvency just to try to annul the transaction towards that party, may that third party anyhow dispute the claims of the debtor and convince the court that there's no a situation of insolvency and there's no need to annul this transaction?
The beneficiary generally not dispute the operation because it benefited of it. Okay. The third part in the action, the third part would benefit of the fraudulent or suspicious act, never intervenes into the collective procedure. It's also the result of the action polienne of nullity of suspect period, which have effect towards him because the operation of which he benefits would be annulled. But he doesn't have any rights into the collective proceeding. The third part never intervenes. Not in community proceeding, it's different.
Thank you. Any questions? Oh, you have a question, please.
Bilal Kurbanov, postgraduate student at the High School of Economics. Ms. Allouche, could you say, please, from your experience as a lawyer, how often the creditors to file the action Pauliana in accordance with 1167 of Civil Code?
To be frank, the action polienne in French bankruptcy law is a very, very, very rare action. Really. Because the act is most often disputed by the organs of procedure in the nullity of the suspect period. The action polienne exists, but they are not really often committed. Sorry.
May I ask another one question?
Yeah.
Sorry. If no one might. The final question about transaction avoidance. Is it possible to annul the decision of shareholders where the debtor is the shareholder and he votes to issue additional shares in favor of a third party, and the result is that his share decreases and the value of its share becomes smaller? Is it possible to annul it in the collective proceeding and under the action polienne?
Yeah, if this decision was passed in the company facing the insolvency. If the debtor is a shareholder of another company, there can be this operation can be disputed. It can be disputed if it concerns the company facing the insolvency proceeding. The third company can be involved.
Marina, attorney at the law of the Moscow Regional District. Is it a common practice when during the bankruptcy procedure managers are responsible for their wrongful decisions, and as you have told that they even can be disqualified for the period of 15 years? Is it often happens?
Yeah. And it's quite often, and the sanction of all these operations against the manager of the company itself arrives in the compulsory liquidation. Okay, because when a company is facing financial difficulty, it began with safeguard or with receivership, most often. And in 60–70%, the receivership is converted into a compulsory liquidation. And in this proceeding, the liquidator have to make the balance. And it shows that the debts are more important of the assets and qualify the insolvency of assets. And in this case, he has 3 years to commit an action against the manager himself to ask for sanction. And the first, as I said, is to obtain the condemnation of the manager to fill the insufficiency of assets. If the insufficiency of assets is about 1 million, the manager could be condemned to pay by himself this million. Because all these fraudulent or suspicious acts could be considered as mistaken committed by the manager during his management of the company. Any question?
Another question. My question is about the chain of fraudulent transactions. Imagine a situation which is very common in Russia when the debtor company intends to transfer its valuable assets to its beneficiary through several transactions, consecutive transactions. Can a court hold all these transactions void in one single proceedings if it discovers that the sole purpose of the whole chain was to transfer the assets from the debtor to the beneficiary?
Yes, because the beneficiary of the first will challenge the beneficiary of the second, and all the operation will be revealed before the court, and they could be void in chain.
In one proceeding?
Excuse me?
The court?
In one proceeding.
Yeah?
Okay.
Yeah. Because all the beneficiary will be forced to intervene in this proceeding.
All the party, every party of each transaction.
It will be a very long proceeding, but the result could be the annulment of all the operation of the chain.
Okay, thanks.
Is this bankruptcy court?
Yeah.
The procedure
In the bankruptcy
in the same
court.
court with.
Yeah.
Any more questions, colleagues?
Another question. I was a bit late, and maybe this question was covered by your presentation, but nevertheless, who is in charge to compose the list of creditors of the debtor? Does the court possess the duty to assess the validity of the creditor's claim, or it's just the receiver's decision, which is suffice to include the creditor's claims into the register? What is the role of the court generally in this proceeding?
The court only open a proceeding, only a receivership or safeguard receivership or compulsory at the request of the debtor or other part. And since the opening judgment, each people will have a specific mission. The manager, if it still has the right to participate to the management of the company, if it's not disvested by the receiver or the liquidator, has an obligation to declare all his known creditor. When all these creditors known are declared by the debtor, they will receive an advising by the judicial representative in the receivership and the liquidator in compulsory liquidation to invite them to declare their claim. They have 2 months from the opening judgment to declare the claim. But if the manager forgets, who doesn't want to declare one of his known creditor, the creditor would have the possibility to make an action before the court to ask for the taking in account his claim, because it wasn't declared by the debtor and he doesn't knew before or by his own the opening of his procedure, and he could declare his claim after the 2 months statute. You wanted to know the
bankruptcy case.
Yeah. The court doesn't have any role in the conduct of the proceeding. It can be consult and says for the closure of the proceeding, for the adoption of plans. safeguard, recovery, or disposal. And the court, when it says for the adoption of the plan, fix the condition would be had to be gathered for, by the beneficiary of the plan. The third part, we're gonna buy the assets of the company and would continue the company.
Any more? Then let's go to the part 3.
Okay.
Thank you.
In this part, I will talk to you about the community insolvency proceeding. I will start by some reminds. The regulation number 1346/2000 of the Council, which entered into effect in 2002, does not establish a substantive law of the insolvency common to the member state of the Union, because the rights of member states are too far apart, and a uniform law would have required a link between all the legislation on certain points, and it was too difficult. The regulation limits the opening of several proceedings, and failing that, they are coordinated and ranked. There is a main procedure which is intended to produce its effect in all the member states, whereas the secondary procedure has exclusively territorial effect, which is limited to the territory to the court which decided on its opening. However, the opening of a main procedure is recognized directly and without other formality in all the member states, and is it in principle the law of the forum that will have authority to apply it. The regulation contains 3 appendices. Appendix A covers the relevant procedure of insolvency in every member state. Appendix B refers to liquidation procedure, because the secondary procedure could only be liquidation procedure. And Appendix C lists the professional in each member state that must be qualified as trustee of bankruptcy within the framework of European insolvency proceeding. But after 10 years of application, it seems necessary to revise this regulation, and the regulation 2015/848 of the European Parliament and the Council of May 20th, 2015 on the insolvency procedure retains the majority of the rule of the first regulation, but brings substantial innovation. There is still no adoption of a uniform law of insolvency proceeding in the Union, but the principle of the application of the law for Rome is maintained, because the determination of the jurisdiction of the court which opened the procedure thus remains fundamental, because it determines the applicable bankruptcy law. It's always the court of the place of the center of main interest of the debtor which will be competent. For legal entities, the center of interest is presumed to be the place of the registrator office, or the place where the debtor usually manages his interests. There is the creation by the member state of register, in which will be published the information concerning the proceeding of insolvency, whereas the Commission will have to set up a decentralized system allowing the interconnection in these creditors in this register to improve the communication of information to the creditors and to concern jurisdiction, and to avoid in particular the opening of parallel procedures. The courts will now have to cooperate when they decide to open the main or secondary procedure. The other innovation is the Chapter 4, which is now related to the procedure of insolvency concerning the member of a groups of company. When proceeding of insolvency will be open against several companies of the same group, the practitioner of insolvency will have to cooperate. The court will also have to cooperate and to communicate between them. The scope of the regulation, it first has a territorial application. All the states of the Union, except Denmark, voluntarily excluded from the regulation, provide that the center of the main interest of the debtor must be situated on the territory of a member state. In defect, it will have the opening of a secondary procedure. It concerns all procedures based on the collective character, characterizing the insolvency of the debtor and proceeding to his divestment by the appointment of the trustee. Are excluded prevention procedure, like in France, ad hoc procedure and conciliation, and the procedure against bank and insurance company. The main procedure, the competent court for the opening is the one of the place of the state in which is situated the center of the main of interest of the debtor, is head office. The procedure is open at the date on which the decision of opening become effective and proceed to the divestment of the manager to the appointment of the trustee. The procedure to seize the court are governed by the law of opening state, but the court has to verify that it is very competent territorially and towards to the criteria of opening. There is a principle of full recognition of any decision opening a procedure of insolvency in other member states, excluded Denmark, and without any other formality in any other member state, that the opening decision have the same effect that the law of opening state give to it. The consequence is the exemption of exequatur, the extension to the procedure to all the assets of the debtor, and a general effectiveness of the judgment of opening, because it produces effects even in a state where the debtor could not be the object of the procedure of insolvency according to the law of these states. There is a limit. A main procedure opened in a member state cannot be extended to another entity whose head office is situated in another state if it's not demonstrated that the center of its main interest is situated at the place where the main proceeding is open. So it's not be possible to open an action, to commit an action for confusion of patrimony or fictitiousness of the company. The applicable law to the main procedure is the law of the forum because of the procedural and execution characteristic. The law of the forum determines the condition of the opening of the procedure and its conduct, the closure of the procedure, the debtor's power and his divestiture, the appointment of the trustee and his power, and expenses and spending of procedure. The trustee has the authorization to act on all the assets of the debtor situated in another member state in the same way as towards the local assets. Thus, according to the law of opening, the trustee can move the assets of the debtor, transfer them in the center of the main interest, so in the place of the procedure, conversely dispute the transfer of the asset operated after the opening of the procedure, commit any action in nullity or non-inopposability useful to the interest of the creditor, and realize the assets of the debitor. But the trustee cannot disregard the public policy of the other member states which would be concerned or the right of the other parts. For instance, It can disregard the real estate rights of thirds on the asset of the debtor situated in another member state. It can disregard the right of a seller benefiting from a clause of property reserve or from a buyer of a good sold according to the same condition by the debtor when the considered asset is situated in another member state. It cannot disregard the possible powers of another trustee in case of secondary procedure because it can intend in this secondary procedure, and the trustee cannot disregard the legal rule of the state, in particular for the realization of the assets of the debtor. The situation of the creditor is the same as in French law because it exists a principle of equality between all the creditors. It has some consequences like the termination of individual proceeding and interruption of proceeding pending in accordance with the law of the forum. The creditor have the prohibition to obtain total or partial payment of the claim by enforcement measure on the asset of the debtor located in another member state after the opening of the main procedure. They benefit of protection from a real estate right of one of the assets of the debtor at the time of the opening of the procedure, and it exists a prohibition to question their rights concerning the assets of the debtor, wherever they are. Let's talk about the creditor who benefits of the retention of title sale. The seller is not subject to the constraints and effect of the collective procedure opened against the debtor, and he may recover his property under the contractual clauses, like if the debtor was in bonis, solvent. But the opening of proceeding against the insolvent seller is not a cause of resolution of the sale and does not preclude the buyer to acquire the ownership of the property sold, provided that the property is in the territory of another state and, naturally, against the payment of the price by the buyer. The creditor also have the right to declare their claims, and they can declare their claim in all the procedure, main or secondary procedure, opened up against the same debtor. The trustee has the obligation to invite the creditor knows to declare their claim, and the creditor has the right to participate to the distribution of the product of the realization of the assets of the debtor according to the law of Rome, which fix rules and rank. A secondary or territorial procedure. A secondary procedure could be open in a state where a debtor has such an establishment after a main insolvency proceeding has been initiated in the center of its main interest. But a secondary procedure must be a liquidation one. The procedure is called territorial if it's open to the head of an establishment belonging to the debtor before or independently of any main proceeding. The establishment could be defined as any place of operations where the debtor exercises a non-transitory economic activity with human means and assets, like branch, office, agency. These procedures are limited toward their effects on the assets situated on the territory where they are opened. There are two hypotheses of opening of the territorial procedure. The opening condition provided by the law of the state of the setter of the debtor main interest are not gathered and preclude the opening of proceeding toward this debtor. and the opening of such territorial proceeding may be requested only by a creditor domiciliated in this state or who is in possession of a claim relating to an operation of that establishment. That it could not have any opening of the procedure at the request of the debtor, the public prosecution, another creditor, or by the court says itself. The opening of a secondary procedure can be initiated at the request of every person of authority entitled to ask for this opening. In France, it could be the debtor himself, an unpaid creditor, prosecution, or the court itself. The trustee of the main procedure can also ask for the opening of a secondary procedure if the patrimony of the debtor is too complex. For the secondary procedure, it's not necessary to verify the insolvency of the debtor because it was verified during the opening of the main procedure. The effect of the secondary judgments only have territorial vocation because the secondary proceeding does not produce cross-border effects. For the secondary or territorial procedure, there is a coordination with the main procedure with the introduction of your duty of mutual information and coordination between the trustee. There is an obligation to open a liquidation procedure unless if the law of the forum provides other possibility. In France, not the liquidation by the sale of the company, but a sale limited to the assets of the company. The trustee of the secondary procedure see its power limited on the asset of the debtor situate in the state of opening. The trustee of the main proceeding can request the suspension of the operation of the secondary procedure, or he can request the release of the suspension depending on the needs and objective of the main procedure. The creditors are also authorized to declare the claim. Although the secondary procedure is inevitably a procedure of liquidation, the applicable law can provide its clause without any liquidation by a disposal plan or by a concordatory solution allowing the debtor to avoid to sell the assets. The trustee of the main procedure can also propose its measure. But since the notion of concordat is not recognized in certain states, it's likely that the regulation will again be amended to integrate the receivership into Annex B. The distribution of the product of the realization of assets of debtor is realized according to the law of the forum. A creditor has thus the possibility to be indemnified in all the procedure in which he declares his claim, but provided that the creditor on the same rank in the other procedure could obtain the same dividends. The judgment opening an insolvency proceeding shall be recognized without any other formality in all the member states as soon as it produces effect in the state of opening. Decision concerning the conduct and closure of the proceeding shall be similarly recognized, and the effect products in the other member states are those conferred by the law of the opening states. But a member state may refuse to recognize an insolvency proceeding in another member state or to execute a decision taken under that procedure where such recognition or enforcement would have effect manifestly contrary to its public policy, its fundamental principle, or in the rights and fundamental liberties guaranteed by its constitution. The fundamental guarantee of fair trial and the right of defense may be taken into consideration. The contrariety of the decision of opening of the procedure in the national public policy does not, however, constitute a mean for the national court to appreciate the contents of the law of the procedure of insolvency of the other member states. I will now explain you our judgment of an insolvency procedure rendered against a debtor situated outside the European Union can be enforceable.
In France.
And maybe in Union, but particularly in France. I don't know if you know the notion of exequatur.
Yeah, of course.
This includes judgment relating to procedure whose settlement of difficulties met by debtor who are relative to a situation of cessation of payments, insolvency, or disruption of credit of the debtor and susceptible to end in a liquidation under judicial review, for which an international convention doesn't settle the effects. These judgments have in France different effects as they have or receive the exequatur or not. The exequatur of a foreign judgment was refused in conformance with the French international public policy in case of breach of the equality between the creditors, the suspension of the proceeding, and the divestment of the debtor. In case of exequatur, the judgment benefiting of will produce effect according to the law of bankruptcy applicable to the place where it was rendered. This effect applies even to the events which occurred between the date of its pronouncement and that of the exequatur judgment, as far as the effects which are attached to it by the foreign law of bankruptcy are not contrary to the French international public policy. The exequatur of the foreign judgment makes impossible to open a bankruptcy proceeding in France. But in absence of exequatur, the effects of the judgments vary according to the object of the call rule. The judgment does not preclude the opening in France of a collective proceeding against the same debtor, and all the creditor can declare the claim in this proceeding without distinction of nationality and without, in case the debtor has in France a branch, to require a link between the claim and the activity of the branch, because the branch does not have the legal patrimony nor personality. The judgment cannot be used to enforce measures in France. It does not imply the investment of the debtor, is not enforceable against the creditor, and does not lead the suspension of the proceeding instituted in France against the debtor unless the judgment is subsequently exequaturate. But the organ of the procedure appointed by a foreign judgment can act in France for the recovery of the receivable of the debtor. The common law procedure for exequatur is some specific. The party who intends to rely on a foreign judgment in France may apply for recognition and enforcement in order to confer upon the foreign judgment the authority of res judicata and enforceability of which it is otherwise lacking in France. The competent court is the County Court, Tribunal de Grande Instance, ruling to a unique judge, either of the defendant's domicile, in the absence of no domicile of the defendant in France, the domicile of the plaintiff, or the place of performance. The recognition and the exequatur of a foreign judgment must be granted if the condition of due regularity shall be established by the judge. The foreign judgment must be rendered by a competent court, and it must not be contrary to French international public policy, and it must not have been obtained under fraudulent condition. The foreign judgment must be enforceable in its country of origin in accordance with the requirements of the law of that country. But the judgment of recognition and exequatur can have not the effect of modifying the foreign judgment. However, is it possible to add specific execution rule? The execution of the foreign decision declared enforceable in France is, by consequence, subject to all the French law principle, not as regard tembar. May demand the exequatur of judgments. For an insolvency judgment, the foreign syndic, to request the extinction of the effect of the decision appointing him toward the asset of the debtor situated in France, the debtor himself with regard to the judgment concerning him. An enforcement proceeding of a foreign decision rendered on liquidation of property is not a substantive proceeding and therefore does not fall within the category of cases to be communicated to the public prosecutor. As in common law, the judge of the exequatur does not have the power to review the foreign decision. He can only verify that such a decision subject to his control has not devoted a fraud to the law, in particular by looking for if the parts did not voluntarily modify the legal relationship in order to remove it from the competent law. But the judge can specify in order of exequatur certain elements appearing in the motive for the foreign decision which are necessary for its execution in France or which can facilitate it, for example, fixing the date of cessation of payment. If the foreign judgment is exequatured, the foreign law of the place where the collective procedure has been opened must be applied. In case of refusal of exequatur, the foreign judgment will not be recognized in France and therefore cannot be executed since it will be considered as enforceable. The effects of the exequatur are some specific because the French creditor of the debtor will thus have the right to declare the claim without taking into account the possible remission of a debt given in the foreign judgments. All other prohibitions applicable to French creditor are therefore not applicable only because of the opening of insolvency proceeding against the debtor in other countries. It concerns the suspicion of individual proceeding. And to finish, let's make some comparison without the rule applicable in some procedure. For the nullity of the suspicious period, the law of opening determines the rule relating to the invalidity, annulment, or non-enforceability of acts prejudicial to all creditors. The court of the procedure shall remain competent to know a revocation against a defendant not domiciliated in the territory of a member state, even if the court of the third state are not required to recognize, enforce the decision of the court which initiated the procedure. But the defendant at the action of nullity, the beneficiary of the act prejudicial to all the creditor, must prove that the concerned act cannot be attacked on the basis of the law applicable to these acts. But not only the act can be attacked by the applicable law of insolvency, but also by application of all the provision and general principle of the law of the act. As part of the nullity of the suspicious period, the compensation of claim is prohibited except in the case of related claims. However, in the event of the opening of a European insolvency proceeding, compensation is enforceable against the French procedure when is it permitted by the law applicable to the insolvent debtor's claim. The French bankruptcy law imposes a principle of equality between the creditor. They must be not favored, notably by a payment. This is a principle of internal and international public policy. But this principle is rejected in the case of the opening of an insolvency procedure, since a different treatment is reserved for certain creditors who thus escape to the rule of the law of the opening. For example, there is a principle of preservation of the real rights of creditor or third part in the debtor asset situation in the territory of another member state. And the effect of insolvency proceeding within the meaning of the regulation on procedure are governed exclusively by the law of the member state in which proceedings are pending. Finished?
Any questions, colleagues?
Yes, my name is Evgeny Kurakin. I would like to, can we stick to the nullity of transactions, and can we go to page 14 of your presentation? Because
14?
14, yeah, 1-4.
This one?
No, it's 16. It seems to me.
14.
Yeah, so you indicate here that the four persons, or four bodies which can request the nullity of a transaction. It's the receiver, judicial representative, the commissioner, and the prosecution. We don't see here creditors. So
we don't see?
Creditor. They cannot do that.
Now, the nullity of the period of suspicion is an entitled action. It can only be committed by the representative, the organ of the procedure. The creditors could also dispute an act with the action polienne.
Okay. In this case, so as far as I understand, you indicate here there are two types of nullity: the nullity of right, and subsequently you indicate the 11 cases. Mm-hmm. And how does, for example, the prosecution knows that this is one of the 11 cases? How the prosecution obtains the information on such transactions in practice?
With the penal action of the creditor? Criminal procedure again committed by a creditor. Okay. Leads the prosecution to commit the action of nullity. Okay.
Is it an established practice in France to initiate criminal proceedings during this bank? Okay.
Non-official.
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 Even non-official, which could be basis of the challenging the transactions.
Yeah.
Okay. So in this case, another question. So. How does the creditor in the bankruptcy proceedings could challenge the transactions which were made unfavorable for the debtor or for other creditors?
They only authorize possibility if the action polienne,
which is very, very, very,
yeah,
very rare.
Very, 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 very rare. But the creditor have very limited rights in French bankruptcy law. When the proceeding is open, they only have the right to declare the claim. They can't commit any action against the company to be settled. If such an action was opened before the opening of the judgment, the action is interrupted. The creditor has to declare his claim. He can remove his action, but only to see his claim fixed on the liability of the company. The receiver of the liquidator had the mission to realize all the assets of the debtor. The product of this realization is first used to pay creditor. But there are some rank in the creditor. The first, the state, privilege, overprivileged creditor, sometimes privilege or challenge with the employees. And the third rank is the secured creditor, and fourth rank, unsecured creditor. If the product of the realization of the assets is null, the unsecured creditor gets 0. So they can't challenge anything. They could only have the right to declare the claim and have the possibility, very, very, very low, to get money back. But after the end of the procedure would be about 3 or 5 years.
And my last question, in Russia, there's quite common procedure to challenge the transactions based on the abuse of right, Article 10 of the Russian Civil Code. Do you have the same provisions in the French Civil Code? I guess yes. And how does it work? Can we challenge the transactions based on this right or not?
Based on, excuse me?
Abuse of right.
It's one of the conditions of the action polienne.
Yeah. Okay.
They give action polienne. They don't need to use this conception. Okay, any more questions, colleagues?
Yes. Alexander Ronjin, attorney of Moscow region bar. I have 2 questions. The first one, how often criminal law rules or criminal law mechanism is used in France to protect debtor and his creditors? How often criminal law rules are used in France in order to try to punish the person who is liable for bankruptcy or for unlawful acts during the bankruptcy? Is it usual practice or it's just a rare precedent?
No, it's a rule. It's a real practice, but as I previously said, it's criminal rule, but it integrates in the commercial code the possibility to ask for the sanction of the manager who has committed a mistake in his management. There are mechanisms of criminal procedure used before the commercial court and the court of the procedure. It's not a real criminal proceeding against the debtor, but there are the same mechanism. There are the public prosecution, and the public prosecution could seize itself to commit an action against the manager who have committed management mistakes. But in the most of the case, this action is committed by the liquidator, because during the compulsory liquidation, he has managed the company and he could have seen really precisely the management of the debtor and the mistake committed.
And the second question, in Russia in recent years, the practice of so-called subsidiary liability of the management, when there are not enough actives of debtor to pay to the creditors, the management of the company of the debtor is subsidiary liable for the debts. Is it, and now I think that the practice, some years ago it was a very rare practice, now it's a little bit more cases. And how the situation is in France in this respect?
The company is not liable because the company has to face the difficulty. In French bankruptcy law, it doesn't exist a distinction in French bankruptcy law between the company and the manager for the opening of the procedure and for the settlement of the claim.
But
if the company
personal liability of management is not used in...
Yeah, but at the end of the compulsory liquidation, that the manager can be personally condemned to fill the insufficiency of asset and personally paid a sum fixed by the bankruptcy court, and it will be distribute between all the creditors.
Is it usual practice?
Yeah.
It's
Yeah.
okay.
The liquidator often say that the action in sanction against the creditor can be committed when the insufficient of assets is about $100,000.
Okay, any more questions, colleagues?
Thank you.
I would like to get back to cross-border issues. I'm of course especially interested in situations when French and Russian laws are concerned, because as you know, we are not a member of EU, and as I have heard one of the president candidates in France declare that France has to leave the EU like the United Kingdom, but still it's a part of the EU. So my question will be about the Russian law. The first question will be, is it possible for a Russian citizen to file for bankruptcy in France if he moved to France and he has some assets in France, but most of his creditors are located in Russia?
Yeah, with the secondary procedure.
Only secondary?
Yeah.
On the secondary. Okay. And the second question will be, how do you think in practice, is there a good chance to recognize and enforce in France a Russian bankruptcy decision against a Russian debtor who has French assets and whose most creditors are Russians, but he has some assets in France? Is it really possible?
Yeah.
Or
Yeah, if the Russian judgment is not contrary to the French public policy, if the Russian judgment was not obtained in fraudulent condition, the exequatur is a very often proceeding in France.
Okay, thank you. Any more questions, colleagues? Okay, then I think we should finish our meeting. Oh, sorry. I would like to thank Madame Allouche for her wonderful presentation. As I have already mentioned, she allowed to publish the presentation and the record of the meeting on the website, so those who are interested will have a possibility to look through it and to listen to the record. And I also would like to think that's my mistake. I'm very, very sorry, terrible, sorry. But I would like to thank the man who organized this meeting and helped us to invite Madame Allouche. This is Mr. Yuri Kulagin, who is sitting right to Madame Allouche. Thank you very much for helping us to organize this visit and this meeting. I hope it will help us to understand better the French insolvency law, because its experience is very interesting. And I would also like to make some gifts to Madame Allouche. The first one is a gift from the Alexeev Private Law Research Center. This is an English translation of a Russian civil code. Maybe it would be interesting to you.
Thank you.
And I have another one gift. It's a personal one from me. That's a copy, a contemporary copy of a French painting This painting was made in the 14th century. And we have here a French noblewoman, and she has a green hat. And what does it mean? It means that she's insolvent. Because in ancient ages in France, if someone became insolvent, he had to wear a green hat, so that everyone could know it. There were no electronic registers and so on, but a green hat knows, please take into account, he's insolvent. So that's for you too.
Thank you.
So would you like to add something?
I want to thank you for giving me the opportunity to make this lecture. That was my first one.
Hope not the last.
It was very interesting to prepare and to make with you. So thank you to all of you.
So, and the final one will be that we have, of course, some more meetings planned, and the Bankruptcy Club is continuing its work, and the next meeting will happen this month in Cahen on 20 and 21st of April in Cahen, and we are planning the next Moscow meeting maybe in 11 or 12 in May. Please take it into account. Please do not forget we have a Facebook web page. It's called Bankruptcy Law. So those who are not there, please log in, and we will be glad to see you here. So that's the end, folks. Thank you very much. Have a good day, everyone. Goodbye.